penalty for concealment of income, law before and after insertion of section 270A of the Income Tax Act. To escort our session chairman, Shri N M Ranka sir, I request Shri Hemant Parab of AIFTP to do the honors. Requesting Shri Ashok Magnani and Arvind Jain of TPA to escort our speaker of the session, Shri V P Gupta sir, to the dais. With a great round of applause, please welcome, and other dignitaries are please requested to take their seats on the dais. Friends, it's a matter of great pride and privilege to be introducing a legend in himself, Shri N M Ranka sir. A reputed senior advocate in the field of tax law, a philanthropist, a tax expert of national repute. AIFTP has honored him as AIFTP Man of the Millennium and Jain Sevaratna by Shri Jain Seva Sangh, Mumbai. Sir has been a chairman, faculty, brain trust trustee at more than 750 tax conferences, seminars, workshops in different parts of India. He is co-author of Hindu Undivided Family Taxation and has compiled many books. He has also authored his biography with the title Law Profession, My Experience and Expectation. His immense trust in Gandhian philosophy and other qualities are really commendable and highly appreciated. With a great round of applause, please welcome Shri N M Ranka sir. Our speaker for this session, Shri V P Gupta, a veteran advocate, has an experience of more than 45 years dealing with direct tax law. Cases argued by him are regularly appearing in the journals. He has also written articles, has been participating and addressing many seminars and conferences. An active member of Direct Tax Committee of PhD Chamber of Commerce and Industry. As an active member of the AIFTP and of Direct Tax Committee, he has made representation from time to time before CBDT tax authorities, committees, commissioners appointed by government. He has also filed a PIL on behalf of AIFTP in the matter of delay in hearing and disposal of appeals by the Commissioner of Income Tax, which is presently going on before the High Court. Please put your hands together with a great sense of pride. We welcome Shri V P Gupta sir. At this juncture, I invite Shri Ranka sir for your introductory comments.
Around the world, it is highly exclaimed. In one's life, two things are certain. One is payment of taxes, and another you know. Today or tomorrow, we have to leave this world. And we should leave the world with such a note that larger section of the society remember you. That should be the aim and object of each one of us. Friends, avoidance of tax and evasion of tax unfortunately has become a highly common feature in this great country known as Bharat or India. unfortunate thing it is. However, because it is a natural phenomena in larger section of the society. But it need to be curbed, restricted, banned. And I for myself have always been mentioning evasion of tax is a crime, not against one person, but whole of the society. But different persons have different thoughts, different outlooks, different way of escape. That is the reason that in the 1922 Act also we had the expression concealment of income or furnishing of inaccurate particulars contained under section 28(1)(c) of the 1922 Act. And it continued after its repeal by 1961 Act, finding that it needs explanation, expansion, or clarification. That's why subsequently, one after the other, 7 explanations were added. There had been long drawn litigation throughout the country, and probably the largest number of judicial precedents in respect of any section. If we will work out, you will find on section 271(1)(c), starting with Anoroli and later Petrochem, Magdata, etc. In my view, legislatures have rightly apprised with the real situation and simultaneously the lack of competence on behalf of the tax administrators, resulting in escape of liability for penalty. That's why rightly thought of doing away with age-old section 271(1)(c), introducing a new concept, section 270 capital A, unreporting or misreporting. Unreporting with a liability of penalty of 50% of the tax avoided. But there is an escape route. If you want to come to the right side, correct yourself, pay the tax, don't file an appeal, and let it be known what is the manner in which that income has been earned. And you get a total And from whom? From the assessing officer himself. You will not find in the history of tax laws that waiver contained in section 270AA by an income tax officer. We have the provisions 273A, but with the commissioner and with many hazards. For misreporting positively and rightly so, penalties 200 times and severe in nature. But still I understand it. Old provisions up to 300 times was the penalty, which has been reduced to maximum of 200%. Apart that, one attracts the liability for prosecution. And if you look to the Customs Act, now GST, even right of arrest has been given, which for God's sake not yet introduced in the Income Tax Act. But if this multifarious activity, anti-national activity continues as hitherto past, there is every likelihood that right of arrest may also be introduced in the Income Tax Act as well. Friends, with these opening remarks, I humbly request the learned speaker, who is an eminent advocate of Delhi, widely known, an expert on income tax, I appreciate Gupta ji when on 29th of last month he was with me at Manipal Ranka National Moot Court competition. Earlier Mr. Varma was also there. And it is highly creditable. The chief guest, Honorable Mr. Justice A.K. Sikri, mentioned about you not twice but thrice in his inaugural address. That expresses how much in-depth knowledge he has and what are his public relations or relations with the judiciary. With these opening remarks, I humbly request my close friend, colleague, to express his views and elaborately explain in respect of prosecutions. Because now a time has come where Central Board of Direct Taxes is threatening we shall be going for prosecutions in a large number of cases. Therefore, the provisions in relation to prosecutions, preliminaries, we must understand, because primarily before the criminal courts, ultimately you may prefer to brief the counsel in the criminal courts rather than to do it by yourself. But if you have the basic knowledge, you will be better able to explain and prepare him how to safeguard the interest of your client. Thank you.
Thank you, sir, for those opening remarks. The floor is yours, Gupta.
Honorable Sri Ranka sir, sir, I am highly obliged to your good self to saying few words about me. I don't know whether I deserve for all this or not. Honorable past presidents of Adv Mrs. Premlata Bansal, Mr. Abel Patradi, so Mr. S. R. Varma sir, who is giving continuously guidance to us in all the matters, in fact. K.L. Goel sahab, an advocate from Chandigarh. All seniors, my seniors and friends, ladies and gentlemen. Today's topic has been given to me by the organizers, Penalty and Prosecution under the Income Tax Act. This topic is so wide, if we try to cover all the provisions of Income Tax Act regarding to penalty and prosecution, probably it may not be, we may not be able to finish even throughout the whole day, in fact. So for that reason, I have prepared two charts giving full list of the provisions relating to penalty and also relating to provisions. Those charts have already been printed in the souvenir. You might have seen all those charts. These charts regarding penalty is on page 83. It starts on page 83 and goes up to page 89. And then for prosecution, it starts on page 90 and page 92. So, I am not going into detail in all those provisions, but broadly I may say that penalty is leviable for all sorts of defaults like not filing a return, not replying to notices, not attending the office. Apart from the main provision regarding concealment and furnishing of inaccurate particulars, or now section 270A, which is for underreported or misreporting of income. Similarly, prosecution is there for all sorts of defaults under the Income Tax Act. I will be discussing only the prosecution in the context of the evasion of tax in the return. You see, initially I had thought of that I will be not giving a presentation. I have already written an article. I have covered all the things, important things in that. But now, today itself I thought, because I was already having this presentation, that in order to understand the scope of section 270A, new section, and 270AA, it is very important to go through the language of those sections. For that reason, I requested the organizers to put this presentation so that we have the language in front of us. What are the specific languages have been there in the earlier section and the present section, so that we can analyze what has been the law earlier and what is the law now. So that is the basic purpose. For prosecution, I will be not giving any presentation, but I will be discussing without that. Now, starting with this presentation, in fact, earlier, as Ranka sir has already mentioned, we were having the provisions of section 271(1)(c) of the Income Tax Act, which was dealing with the penalty provisions, penalty for concealment of income or for furnishing of inaccurate. Now, in that section, I'll just request that kindly keep in mind the language which will be there in the old section. Earlier section 271(1)(c) is in force up to assessment year 2016-17. So by and large, assessments have already been done or will be completed by December this year. So this 271(c) will be applicable only in regard to those assessment years. After that, from assessment year 2017 to 18, provisions section 270 capital A of the Act will be applicable. Sir has in fact mentioned that probably this has been done to simplify. This is very right. The purpose of section 270A has been, I'll just show from the memorandum, that purpose has been to simplify, bring certainty, subjectivity of that. But we'll see whether it serves the purpose or not. We will be having discussion on that. Now, Section 271A1C provided that if the assessing officer or the Commissioner of Appeal or the Commissioner in the course of any proceedings under this Act is satisfied that any person has concealed the particulars of income or has furnished inaccurate particulars of such income. Here words are that either assessing officer, Commissioner of Appeal, Commissioner could initiate the proceedings. In any proceedings, he could initiate the penalty proceedings with the condition if he is satisfied. So this word is very important, has been there in the earlier law, that he has to be satisfied. And then the words have been that if income has been concealed or inaccurate particulars have been furnished. So these are the important conditions which have been there in the earlier law. And these conditions have been subject matter of litigation, as Ranka sir has already mentioned, that the issue started from the Anwar Ali case, 76 ITR. All these cases are there in my article. You need not note down on that. Then there have been a number of decisions on the line whether the concealment or inaccurate particulars require the mens rea or intentional default or not. All these cases were to the effect that there must be intentional default or concealment, then only the penalty proceedings will be attracted. But in between, a decision of the Supreme Court came in the case of Dharmendra Textile, which created some confusion as regards this legal proposition, that said that mens rea is not required in case of a penalty under the Income Tax Act because it is civil liability. That was the case of excise, but provisions are the same. It is a civil liability, as the mens rea will be required in case of prosecution. So that decision created some sort of a problem. But subsequently, fortunately, again Supreme Court explained the position in the subsequent cases, Rajasthan Spring, that no, intentional default is necessary for imposing the penalty. And latest and most important decision, as Ranka sir has also mentioned, is a Reliance Petro Products. That decision is very important for the reason, in that decision, the Supreme Court has said that even if I make a claim, if I made a disclosure, claim may be incorrect in law and that may not be accepted by the assessing officer, still penalty cannot be levied. So that decision is very important. After that, there is another decision also in the case of Pricewaterhouse, that is also mentioned in my article. In that case, the provision for gratuity was, Pricewaterhouse is a big firm of chartered accountants. In their own case, provision for gratuity was disclosed in the tax audit report, but they had not added in computation of taxable income. So in that situation, the issue arose whether penalty can be levied or not. The matter went up to Supreme Court, and Supreme Court said that mistake can be committed by anybody. Even if they are a big firm chartered accountant, that doesn't mean that they cannot commit a mistake. So once they had disclosed in the tax audit report, in spite of the fact that provision for gratuity was required to be added in terms of section 247 of the Act, it was just a mistake and penalty could not be levied. So, if we see the High Court decisions on regard to those matters, almost in every part you will find at least 2-3 decisions regarding the penalty. Because in every case, the department initiate penalty proceedings, also levy penalty, if matter goes to the courts, then it is held whether penalty is leviable or not. General principles, well, I am not going to all that case law, but general principles which has emerged out of those decisions are that penalty cannot be levied if the disputes relating to year of taxability or the disclosure have been made in the return or the bona fide mistake is there or penalty is not available when the issue is debatable. Well, all these principles have emerged out of the decisions that if there is a bona fide mistake or debatable issue or claim is based on certain advice or based on legal propositions, then penalty is not leviable. Penalty can be levied only if there is a intentional default or intentionally the person has evaded the tax, then penalty is leviable. That has been the broadly principles which has emerged out of the various court decisions. Now, with this little background, we come to the new provisions of section 270 capital A of the Act. Now, before going to the section, if we just read what has been the background, the memorandum, what they said. This is the memorandum under which the provisions of the section 270A have been inserted. So we have to see whether what is stated in the memorandum, the section serves that purpose or not. Memorandum says, under the existing provisions, penalty on account of concealment of particulars of income or furnishing of inaccurate particulars is leviable under section 271C of the Income Tax Act in order to rationalize and bring objectivity, certainty and clarity in the penalty provisions. It is proposed that section 270A1 shall not apply to and in relation to any assessment year from assessment year to the commencing on or after 1st April 2017 and subsequent assessment years, the penalty be levied under the newly inserted section 270A with effect from 1st April 2017. So object very clearly has been to bring objectivity, certainty and clarity in the provisions. Now if we come to the provisions language of the sections, now let us analyze and see how far the object has been achieved by this section or not. Now this section 270A, capital A, has 12 subsections in fact. Subsection 1 of section 270A provides that assessing officer or the commissioner appeal or the principal commissioner or the commissioner may, during the course of any proceedings under this act, direct that any person who has underreported his income shall be liable to pay penalty in addition to tax, if any, on the underreported income. So this subsection says that any of these authorities can direct for levy of penalty with reference to underreported income. Important word satisfaction is not there in this section. That is first thing to be noted. So we'll have to see what is the effect of that when satisfaction is not there. In the earlier law, assessing officer or any authority which is initiating the proceedings was required to record his satisfaction that on what basis he is alleging that income has been concealed or inaccurate particulars have been there. But in this section, there is no such condition of satisfaction. Maybe the legislator or the intention behind the provision, as it has been mentioned, is that that is not required. State-way comparison has to be made between the returned income and assessed income and penalties to be levied. That is what probably background has been. This is why they have removed this word. So that is what they wanted. Going further, subsection 2 provides for the circumstances in which the income shall be considered to have been underreported income. Clause A provides that income assessed is greater than the income determined in the return processed under subsection clause A of subsection 1 of section 143. So what it says, underreported income shall be considered to be when the income assessed is higher than the income which is determined as in the intimation issued under section 143 1A of the Act. Fortunately, if there is any difference in the income returned and income processed, so that difference will not be considered to be underreported income, and on that penalty will not be levied. This is a fortunate or favorable point in fact. If you have filed return, then processing has been done. If any adjustment is made by the assessing officer during the course of adjustment and 143 1A, that is not covered here under the underreported income. Clause B says that income assessed is greater than the maximum amount not chargeable to tax, where no return has been filed. If you have not filed the return of income, then any amount which is assessed, if it is beyond the maximum amount exempt, that is to be considered in case of underreported income. You see, subsection 2 and subsection 3, in fact, subsection 2 provides that what are the circumstances when underreported income. Subsection 3 provides what is the quantum of underreported income. In fact, in my view, these two subsections are not required in fact, because these are one and the same thing. One could say that underreported income will be as determined in subsection 3. All these same situations are there if we go to the subject. Similarly, when the income is assessed, reassessment is more than the income assessed in earlier, that is deemed to be under assessment income. Further, any difference in 115 JB, JC, etc., that is also covered. So all these circumstances are the circumstances when the income will be deemed to be underreported income. In short, it can be stated that on the basis of the above circumstance that in a case where the income assessed or reassessed is more than the income returned or income assessed earlier, then assessee shall be deemed to have been underreported as income, whether assessed as per normal provisions or under section 150 JB or JCA. Now coming to subsection 3. Subsection 2 only says that these are the circumstances when it will be deemed to be underreported income. Subsection 3 says this will be the quantum of underreported income. Clause 1 of this says that in a case where the income has been assessed for the first time, clause A, if the return has been furnished, the difference between the income assessed and the income determined under section 143(1)(a). Same thing which is there in clause A of subsection 2. Again, if the return has not been furnished, then the income assessed in case of a company, firm or local authority, full income, because in their case there is no exemption. In case of individuals, the income exceeding the maximum exemption limit. So that will be the income quantum. Then clause 2 provides the difference between the income reassessed and income assessed in the preceding order. Then similarly for 115 JB, JC, the difference in the income returned and income assessed. In case of a loss, the difference between the income, if how much is the loss is reduced or turned to the income, that difference will be deemed to be underreported income. Then subsection 4, which is very important of this, provides that if you have, there is some income which is added or which you have said, that source of this income has been my receipts in earlier year. So this provides that if the penalty has not been levied in that earlier year, what you say that I acquired that source of this income is that in that year. So penalty can be levied in this year. On respect to that, if penalty has not been levied in earlier year, this will be considered to be underreported income of the current year. If you say the source of this amount is earlier year, which is included there. So in short, again, the difference between the assessed returned income and assessed income is to be considered as underreported income. So what I said, that both the subsection 2 and 3 have similar provisions, except saying one says these are the circumstances, one says this is the quantum, in fact. Now subsection 6 of this section is very important, in fact. Subsection 1 said that penalty is leviable on underreported income. 3 said what is underreported income. Now 6 says that the amount mentioned here or circumstances which are covered here will not be deemed to be underreported income. So this is an exclusion section. Now we should see what this exclusion is. Clause A provides that amount of income in respect of which the assessee has offered an explanation to the satisfaction of the assessing officer, commissioner appeal, commissioner or the principal commissioner, as the case may be, that explanation is bona fide and assessee has disclosed all the material facts to substantiate the explanation offered. Very important provision, in fact. Under subsection 3, we have said that underreported income means the difference between the income processed in 143(1)(a) and the assessed income. That is underreported income. Now, if the assessee has given an explanation that this is a bona fide explanation, as assessing officer considered that this is the bona fide explanation, and he has disclosed all material facts regarding this particular income, then if the assessing officer is satisfied, then it will not be deemed to be underreported income. Kindly consider what the earlier section has said. Earlier section was saying satisfaction on behalf of the assessing officer, to say that this income is concealed. Now satisfaction is that this is not underreported income. This is a reverse. Onus is on the assessee now to say that this underreported income is to be excluded under this clause because I had made the claim bona fide and all the particulars have been disclosed. Now, assessing officer has to examine that whether my claim is bona fide or not. He has not to prove his case that I have concealed. He has to satisfy as far as my explanation is concerned. And in case he is satisfied, then he will say it is not underreported income, he will exclude, otherwise he will retain this in underreported income. So that is the big change. The process has reversed, in fact, in a way. Now, Other thing, similarly in other circumstances, income has been determined on the basis of estimate by the assessing officer on the ground that the method employed is such that income cannot be properly deduced therefrom. Again, very important thing. What this clause says, income has been determined on the basis of estimate by the assessing officer on the ground that though the accounts are correct and complete, but income cannot be deduced. When this income will be not be considered to be underreported income means that assessing officer say he determines your gross profit on the basis of say 4%. Why, in what circumstances he will determine? When he will reject your accounts, he will say income cannot be calculated on the basis of your accounts. Then only he will say. On the one side, he is making the assessment on estimate basis. For the exclusion purpose, he has to be satisfied that my accounts were correct and complete, but income cannot be deduced. I am not sure whether there can be any circumstances like this. So, again, difficulty. How this will be operative? Then again, then further, income is determined by making a further addition in the amount of estimated disallowance made by the assessee, and assessee has disclosed all the facts material to the addition or disallowance. Assessee has made some estimated disallowance. Assessing officer doesn't agree, as in case of 14A general situation is there. He doesn't agree. Then it will not be deemed to be underreported income only if the assessing officer is satisfied that my estimate was proper and I have proper explanation or full facts of material have been disclosed. Again, same difficulty. When my estimate is estimate, in fact, I may be explaining, I may be giving any circumstances or any justification for that. If the assessing officer is not agreeing to my estimate and he is making a different estimate, obviously he will say that your estimate is incorrect or you have not made proper basis. So again, difficulty. Then this is in regard to transfer pricing cases, international transactions. Income represents the addition on account of adjustment in ALP, arm's length price, in respect of international transactions, and the assessee had maintained information and documents as prescribed in section 92T and had disclosed all material facts relating to transaction. Again, the question is subjective, that you have maintained all documents, made full disclosure, transactions has been disclosed. Then if the addition has been proposed, then if he is satisfied, then that will be approved. Last clause is that regarding such cases, the different provisions are applicable. This is why it will not be deemed to be underreported income in this clause. Now, in case of subsection 7 provides that in case of underreported income, penalty is leviable at the rate of 50%. And in case of underreported income, as a consequence of misreporting of income, penalty is leviable at the rate of 200%. After that, again very important section, subsection 9, that provides what are the circumstances in which the income will be deemed to be underreported income as a consequence of misreporting of income. Again very important. Clause 1 itself says misrepresentation or suppression of facts. If the underreported income is a consequence of misreporting of income, which is deemed to be on account of misrepresentation or suppression of facts, then this amount will not be considered as a simplicity or underreported income. This will be underreported consequence of misreporting income, and penalty will be leviable at the rate of 200%. Now, kindly, before proceeding further, just compare this clause with clause 6, subsection 1, subsection 6, which be clause A, and subsection 9. Clause A here was reading, difference between the returned income and assessed income is unreported income. That is one stage. Second stage is that if I have given an explanation which is considered by him to be bona fide and all disclosure has been made by him, he is satisfied. Then he is he is entitled or he is obliged to exclude that amount from the underreported income, then this will not be underreported income. If he is not satisfied with my explanation, he says, no, your explanation is wrong, you have not made a disclosure. Because here the condition is that I have made the bona fide claim, my explanation is bona fide, I have disclosed all material facts to substantiate the explanation offered. And there subsection 9, one says misrepresentation or suppression of facts. If he is not satisfied with my explanation, that my claim was bona fide and I have made full disclosure in regard to that, then what he will say? Will he not say that you have misrepresented or you have suppressed the facts? Or can there be anything else? At least I am not able to understand this. Either he will be satisfied that my claim was bona fide and I made full disclosure, explanation was there. If he is satisfied, that it will go out of the underreported income. And if he is not satisfied with my explanation, says no, you have not disclosed full facts, your explanation is not bona fide, then in my view, in 100% cases, he is going to say you are misrepresented. You are not given correct facts. So then this will be misreported income. This is on account of misrepresentation and suppression of facts. So that is the, if you read these two subsections together, my conclusion is there will be no case where this will be simplicity or underreported income. Either this is not an underreported income at all or this is misreported income. Second thing, we have seen that there have been a lot of litigation regarding concealment of income or inaccurate particulars. As we have seen that almost every day we see the cases regarding concealment of income. What is the scope and meaning of misrepresentation or suppression of facts?
Actually, can I say something?
Yes.
Sir, non-disclosure of facts is different from misrepresentation or suppression of facts. So far I understand. Non-disclosure of fact is that a particular fact is there and you have not at all disclosed.
If you are not doing suppression of facts,
that cannot automatically be the suppression of facts.
in most of the cases, if you are not disclosed, it is suppression of facts.
Let me complete. Misrepresentation or suppression to hold in some certain type of malafide intention. But non-disclosure may not be always carrying the misrepresentation or suppression of facts. There is a difference between these two.
Very thin difference may be there. Very thin difference may be there.
Humble suggestion. Let him speak on.
Please, sir.
And then we have questions and answers. I will give sufficient time. I believe in that. Rather than only speaking.
I'm sorry.
You should also speak. But that is the appropriate time. Thank you.
So,
Sorry.
maybe a little difference one can say, depending upon the facts of each case, one can argue. But as a general proposition, what I say, broadly, this brings to the same effect. Then there are other things also here which says that non-recording of investment in the books of account, which may be, depending on the facts, may be the key question. Claiming expenditure not substantiated by evidence. Again, we come to the same thing, that if I have substantiated with evidence or disclosed the things, my claim is bona fide, then I am out of underreported income. Here, he will say that you are not given you are not explaining the substantiated explanation with evidence. Then recording a false entry, failure to record any receipts. There may be certain things which are clear or one may be established on facts, but there is a difficulty in regard to certain things. On this basis, we may be having difficulty in arriving at. So, my conclusion on this basis is that in many circumstances, cases will be covered by the assessing officer only in the underreported income as a consequence of misreporting of income if he is not satisfied. And obviously, as we see, it is very difficult to satisfy the assessing officer. Now, these three subsections, subsection 10, 11 and 12, these are procedural sections. Subsection 10 provides that method for determination of tax payable, that is the tax on the income underreported. Subsection 11 is a clarificatory provision that if penalty has been levied in this year on that income or in earlier year, then again it will not be levied. And subsection 12 provides that penalty shall be imposed only on passing an order in writing. Now, before going to subsection 270AA, I may also say one thing. Here the penalty is leviable with reference to the income assessed and the income returned. The authorities which have been mentioned here, the assessing officer, commissioner appeal, commissioner, principal commissioner and all that. In my view, it appears to me, under the old law, position has been that they could direct for the initiation of proceedings, or the commissioner appeal could also levy the penalty. But this was with reference to the particular income conceit. Say commissioner appeal is dealing with the case, he finds during the course of appeal proceedings that you have not disclosed this particular income or this income attract penalty proceedings. So he could issue the notice for 271C and could also levy the penalty. But here the income, it base is the not a particular item of income. Here the base is income assessed and income returned. Who will determine that? In my opinion, it is only the assessing officer who will determine. Even after a commissioner appeal, he will determine the income assessed and income returned. So, in what circumstances the order for penalty will be passed by commissioner appeal or commissioner? So that is also a little confusion in my mind. This authority have just been copied from the earlier section to in this section. In this case, in the new section, it is only the assessing officer who will pass the order as a consequence of the commissioner appeal or the commissioner or principal commissioner under 263, and he will determine the assessed income, and then the difference between the income assessed and income returned can be the underreported income. Probably these authorities can direct for initiation of proceedings, but probably there will be no stage when they will themselves pass the order. This is what it appeared. Either the matter should come back to them after the assessment order is passed. That can be the only situation one can think of. Now coming to section 270AA, as Ranka sir has also mentioned, this is the provision which is providing immunity in the cases where the tax and interest has been paid and appeal has not been filed. In this section also there are certain problems in fact. Section 270A provides for filing an application to the assessing officer for grant of immunity from the imposition of penalty under section 270A and also for initiation proceedings under section 270C and 276CC if two conditions. In tax and interest determined to be payable has been paid within the period specified in the notice of demand. After the assessment is made, the assessing officer issued a notice of demand mentioning what is the amount payable, and normally he gives 30 days time, but he has the power to reduce that time also in certain circumstances. Assuming he has given 30 days normal time, so you will have to make payment within 30 days of that. That is number one condition. Second condition, no appeal against the order has been filed. Then you can file the application for the immunity to the assessing officer. Application is to be made within a period of 1 month from end of the month in which the order has been received. Say order has been received by you in the month of, say today is the 7th October, order is received today, then application can be filed by 30th November, 1 month from end of the month in which the order is received. Tax is to be paid within 30 days by 6th of November. Appeal is not, you are not to file the appeal. Then application can be made up to 30th November. Now, kindly just keep in mind this period which I mentioned. We will come to that. There is a difficulty in this also. Now, subsection 3 of this provides that assessing officer shall, subject to fulfillment of the condition specified in subsection 1, and after expiry of the period of filing of appeal as specified in the clause B of subsection 2 of section 249, grant immunity from imposition of penalty under section 270 capital A and initiation of proceedings under section 276C and 276CC where the proceedings for penalty under section 270A has not been initiated under the circumstances referred to in subsection 9 of the said section 270A. You see, here again I will just emphasize that what the opening word is, assessing officer shall. Important word is shall. Shall means mandatorily. He has to grant immunity subject to fulfillment of conditions specified in subsection 1. Subsection 1 provides only 2 conditions. So if those conditions are fulfilled, then he shall grant the immunity. Probably there is no option when the word shall is used. Other than the cases which are covered in subsection 9 of section 270A, which are the cases where the underreported income is a consequence of misreporting of income. So, probably that is the reading of this section, that in all the cases except those cases which are covered in subsection 9, he mandatorily required to grant immunity if you have paid the tax within 30 days and you are not filed the appeal. I think language of this section appears to be quite clear. That should be the mandate of this. But now subsection 4. Subsection 4 says that assessing officer shall, within a period of 1 month from end of the month in which the application under subsection 1 is received, pass an order accepting or rejecting such application. So my reading of subsection 4 in the light of interpretation of subsection 3 is that he has a power to grant immunity even in those cases where underreported income is a consequence of misreporting of income. Our general presumption or general impression on going to this section is that he will not grant the immunity in the cases where the misreporting income underreported is because of misreporting of income. Sir had also referred to this, that penalty to admit. That is the impression we get, that he can grant the immunity only in those cases. But reading of subsection 3 and 4, it appears to me that subsection 4 gives no liberty to him. He has to grant immunity. Subsection 4 when it says accept or reject, so that will be only in those cases. That's one thing. This is the procedure that he will give the opportunity when rejecting and all that. Now the order passed by the AO shall be final. No appeal can be filed by the assessee in a case where the application has been accepted by the assessing officer. Okay, no problem. Now an appeal can be filed against the order of assessment in case an application for the grant of immunity from the penalty proceeding has been rejected. And now this is very important. And the time limit for filing an appeal before CITA of 30 days is to be determined after excluding the period from the date of filing the application to the date of service of the order rejecting the application. I gave you an example. That order has been received today on 7th of October. I can file the appeal only till 6th of November, 30 days time. But I have the time limit for filing the application till 30th of November. What the period will be excluded? If I file the application after 6th of November, what will be excluded? 30 days time has already gone. Huh? So very surprising. I hope I am clear. Appeal before CITA can be filed within 30 days from date of receipt of the order. I have received the assessment order today on 7th of October 2018. Appeal before CITA can be filed by 6th of November 2018. No doubt? Yes. Now, application can be filed by me before the assessing officer by 30th of November. And this section provides for filing if he rejects application then I can file the appeal before CITA, but for counting the 30 days, the period from which date I have filed the application, till date he rejects the application, that period is to be excluded. So period is to be counted from 7th October till he rejects. So period from the date he will decide after 1 month. I file the application in November, he will decide that. So if I file my application after 6th of October, November, then only that period is to be excluded, but 30 days have already expired. How can I file the appeal? I cannot. नहीं मिलेगा, नहीं मिलेगा, नहीं मिलेगा, सेक्शन नहीं कहता, कैसे मिलेगा? बताएं, सेक्शन नहीं कहता, सेक्शन कहता है कि जिस डेट से आपने एप्लीकेशन करी, उस डेट से रिजेक्शन तक का 30 डेज काउंट करने में आपको पीरियड एक्सक्लूड करना है। वो जैसे कोर्ट में भी, कोर्ट के केस में भी होता है, जिस डेट में कोर्ट सर्टिफिकेट कॉपी लेने के लिए होता है, हाँ सर्टिफिकेट कॉपी लेने के लिए होता है, और अगर कोर्ट इंटरिम ऑर्डर दे देते हैं तो वहां से डेट से इंटरिम ऑर्डर से टिल द डेट फाइल सब में वो एक्सक्लूड करना है, पर पीरियड तो टाइम लिमिट तो आपकी इनिशियली रिकॉर्ड स्टार्ट हो नहीं, तो वो पीरियड मेरा काउंट आज से लेकर के और वहां तक का काउंट होगा टोटल, उसमें से जिस डेट मैंने एप्लीकेशन करी उस डेट से वो एक्सक्लूड करना है। तो 30 डेज तो मेरे पहले ही निकल गए, तो अपनी एप्लीकेशन अपील नहीं कर सकता था। नहीं सर, नहीं, सेक्शन में नहीं है, मेरी रीडिंग ये है, ये एक्सक्लूजन पीरियड में अगर ये कहते, सीधा ये कहना चाहिए था कि 30 डेज फ्रॉम द डेट ऑफ रिजेक्शन मैटर्स, बट दिस इज हाउ द ड्राफ्टिंग इज बीइंग डन। सो दैट इज my reading, and I'm quite confident that there can be hardly any that is separate issue कि वो dismiss होगी अपील या कोर्ट में जाओगे, हाई कोर्ट जाओगे, वो further time extend होगा, वो सब that is separate issue, but section says this position. So for that reason अब ये हुआ कि जैसे ही आपके पास ऑर्डर आए immediately pivot करो और एप्लीकेशन कर दो, so that you are able to save the time for filing the appeal. You cannot avail the full time limit which is available for filing the application. Now, this is, after this I have mentioned some analysis in this, but most of the points we have already discussed. But one very important point rises here. In the earlier process, the assessing officer in the assessment order was initiating the proceedings. He was mentioning that penalty proceedings are initiated separately. In this process, what will happen? At what stage he will determine it is underreported, misreporting, how I will get the chance or opportunity to explain that my explanation is bona fide, I have disclosed and all that. And when this time limit, all that for immunity application and all this will be applicable. There appears to be total confusion. The assessment order he has passed. Today I get the assessment order. What the assessment order will do? Whether in the assessment order itself he will determine this is underreported, misreported, or penalty is levied. What he will do? I don't think that he can do it today. Then how the section 270A will be implemented? How I will make the application? I do not know what is underreported income. The difference is there, but I have the explanation to give. Which it can be excluded, whether it is underreported, is misreported. How this? So where is the time limit? How this process will be there? There is no clarity in the law at all. Secondly, under the old provisions, section 275 provides a time limit in which penalty orders can be passed and all that. So by and large, the assessing officers were keeping the, on our request, though they could pass the order, but they were keeping the matters pending till at least commissioner will decides or maybe approved at that stage. Now here, though there is no change in section 275, same time limits continues. But the process or the basis has been straightway said, return income to assessed income. So assessing officer is most likely, in my view, immediately after the assessment order, he can pass the order for penalty, he can levy the penalty. Then you have to go in the appeal against the penalty order also simultaneously. The position, according to me, doesn't appear to be so as it has been earlier, that he will keep the penalty procedure, because he will say straight away this is underreported income or misreporting of income, penalty will levy. He is not likely to wait till that, though there is no change in section 275. That is what my presumption is. So these are the broad things in regard to the penalty provisions, section 270A and 270AA of the Act. Now coming to the prosecution part. As regards prosecution, again I'll be only discussing about the penalty prosecution proceeding with reference to evasion of tax. Section 276C of the Act provides for prosecution in regard to the willful attempt to evade any tax, penalty or interest chargeable or imposable on income or on underreported income. Here or there. Section provides that if the amount of tax is more than rupees 25 lakhs, then prosecution can be from 6 months to 7 years. If it is for less than that amount, then it can be from 3 months to 2 years. Now, explanation provides what is the willful attempt to evade tax. That says willful attempt to evade tax, evade any penalty, interest chargeable or imposable under that, provides that it will include the cases where any person has in his possession or control books or other documents containing false entry or makes or causes to make any false entry in the books of account document, or willfully causes to omit any relevant entry or causes any other circumstances which will have the effect of enabling the evasion of taxes. That is the willful attempt in fact. Now another important, as a matter of principle, a person is liable for prosecution only when offence has been committed with conscious mind. That is the courts have taken a view that there should be conscious mind, then only the prosecution can be lodged, the malified intention. But for this purpose, the Act has the section 278E, which is very important in fact. That says prosecution for an offence requires that culpable mental state, which is required in every case. That says culpable mental state on the part of the assessee, the court shall presume the existence of such mental state. Very important. Section 278E is very important. It says that when the prosecution requires the culpable mental state, courts will presume the culpable mental state. Further, the accused shall have the defense to prove that non-existence of such mental state in respect of such offence. But in all criminal proceedings, this is for the prosecution to prove that there is a culpable mental state. In income tax proceedings, it is the other way around. In income tax proceedings, section provides that it will be presumed that you have a culpable mental state. This is for the assessee to prove that I do not have the culpable mental state. This is very important in fact as regards to presumption. Now further, not only presumption, but what it says, culpable mental state includes intention, motive or knowledge of a fact or belief in or reason to believe a fact. Then further subsection provide that is said to prove what the culpable mental state should be proved that it is not there only in the circumstances if it is proved that one court believes it to exceed beyond reasonable doubt and not merely an existence is established by preponderance probability. When the assessee explains that I do not have the culpable mental state, not only that by preponderant circumstances he can say that there is no mental state. Court has to believe and consider from the circumstances that yes, he has no culpable mental state, then only. So onus is very heavy in case of prosecution under the Income Tax Act for this, on the assessee to prove that I don't have the culpable mental state, and he has to prove in all facts and circumstances, then only he can escape the prosecution. So this is very important in fact. Now this provision, section 278E, has been considered in certain cases by the courts, and courts have affirmed constitutionally validity also, the provisions also, that it is to be in this particular manner only. Leading cases Prakash Nath Khanna of CCIT, 266 ITR page 1. It is all discussed in my article in fact. Honorable Supreme Court has observed the court has to presume the existence of culpable mental state. Absence of such mental state can be pleaded by the accused as a defense. The aspect whether the accused has been able to prove absence of such mental state will depend upon the facts of the case. Again, all the facts will depend, otherwise onus is on the SSC. Then Madras High Court also considered in case of Jayalalitha versus ACIT that in this case the constitutional validity of the provisions were challenged, which was upheld. Then we have section 277, which provides that in case a person makes a statement in any verification under the Act or delivers account or statement which is false or which knows he believes to be false or does not believe to be true, section provides for rigorous imprisonment. Again, in this case, if he makes the statement, provides any information, so if it is incorrect, then as evasion of tax, he can be liable under this. Same prosecution from 6 months to 7 years and 3 months. Section 279 of the Income Tax Act requires the sanction of the commissioner or principal commissioner. This is very important in fact. In all the cases, the prosecution can be launched only with the approval of the commissioner or principal commissioner. Subsection 2 of section 279 provides for compounding. All we know that there are guidelines for compounding notified by the CBJT. So in most of the cases, it is happening that notice is issued. The commissioner in most of the cases, without considering even the facts and circumstances, without considering your application, he will straightway say you compound the things. And you pay all compounding charges or any other charges around that. So this is indirectly a pressure being built on the SSCs in fact. For any sort of things, notices are issued and they do not even consider the circumstances and they just straightway say that you compound the things and then matter will be sorted out. So this is another thing. Then we have section 278B, which is applicable to the firms or companies or the firms, AOP, etc., which provides that any person who is responsible to conduct a business, he will be prosecuted, who is in knowledge. So that gives a relief to the persons who are not involved in day-to-day activities. They cannot be prosecuted if they prove that I am not involved in day-to-day activities and this offence has not been committed with my connivance or my knowledge. There are certain case law also in what circumstances there will be connivance or consent for the persons. Now, there are certain principles as regards the prosecution proceedings are concerned, which has emerged out of the case law, etc. Now, for example, the law as on the date of default was committed will be applicable. So, which is generally very important and applicable in all prosecution cases, in all criminal process, that on the day you commit a default, as the law stands as on that date, that law will cover the circumstances, not that if subsequently law has been amended, that amended law will not be applicable. That is the general principle of that. Then sanction, as I already mentioned, sanction for prosecution is a must, and that sanction is necessary. But the scope of the sanction, this is a general principle that when granting a sanction, the concerned officer must consider all the circumstances, then only sanction should be granted. In this regard, there is a leading decision of Supreme Court in the case of Mansukh Vittal Das Chauhan, which the Supreme Court in that case has held that order of sanction must ex officio disclose that sanctioning authority had considered the evidence and other material placed before it. Then sanctioning authority has to apply his own independent mind. Then discretion should be shown to have not affected by any extraneous consideration. His discretion should not be affected by any other direction or anything like that. Then sanction is a weapon to ensure discouragement of frivolous and vexatious prosecution, and it is a safeguard to innocent but not a shield for the guilty. So that is a general principle Supreme Court has laid down, that he should apply his mind, he should consider circumstances, then only he should come at a conclusion, and so proper sanction is required in fact. Now another thing comes before granting a sanction, whether opportunity is required or not. Opportunity is to be given to the assessee before granting sanction or not. Courts have held that opportunity is not necessary. Courts have observed this is an administrative matter and commissioner can grant sanction even without giving opportunity to the assessee. But of course, he has to consider all the circumstances and all that. There are certain circumstances in the commissioner cannot grant the sanction. These are the circumstances where he himself has waived the penalty, etc. So there in that cases he cannot take a contrary view. If he waived the penalty or reduced the penalty, he cannot say that prosecution can be launched. Now another very important thing comes, whether penalty prosecution can be launched even when the assessment proceedings or appeal proceedings have not been completed. Courts have taken a view that proceedings can be launched, and it is for the courts to see whether they can be kept pending or they may be directed to be withdrawn and filed subsequently after the assessment or appeal have been completed or not. That is one thing. Now another very important thing is, if there is some holding in the on merits of the case in the normal appeal proceedings, what is the effect of those holdings in the prosecution proceedings? Courts have taken a view that those holdings are very valid and they have to be considered for the prosecution proceedings. And if the, say for example, if addition has been deleted or a firm has been said it is genuine firm, for example, then prosecution purposes different view cannot be taken, or the court will consider the factual holding given in the case of merits of the cases in fact. Now another very important issue comes, whether the penalty has been deleted, for example, whether prosecution proceedings can be launched or not. Courts have taken a view that when the penalty has been deleted, so prosecution proceedings will not be pursued or will not be launched in fact. Now in certain circumstances prosecution proceedings can be abated also when the matters are pending, etc. Now one more thing, that prosecution proceeding can also be launched on account of abatement against the chartered accountants or tax practitioners. That is also we must keep in mind.
Also advocate.
Now, yes, of course, anybody. But what is abatement in what circumstances, that will be, that is very important to consider. If the assessee has already committed, some assessment has been done, and then he comes to the advocate. Now it is the duty of the advocate to defend the case. In that case, no abatement. If you are at the first stage, he comes to you. ये सब मैं ये करने जा रहा हूँ, कर लूँ क्या? आपने कहा कर लो. That is the abatement. Similarly, in case of a chartered accountant, say he brings the vouchers and say, prepare my accounts and return. Chartered accountant does it on the basis of information given to me, no abatement. But if he consult the chartered accountant, whether should I show the purchases like this or expenses like this, and he concur कि yes ठीक है कर देते हैं, then there is abatement. So this is a very important thing, that we should, in what circumstances abatement can be there and what circumstances cannot be there. Now another aspect in this regard, last thing, whether when the sections have provided a sentence, 6 months to 7 years, so 3 months to 2 years, whether the court can reduce those punishment or sentence. Court's view is no. Once the section has laid down, it has to be 6 months to 7 years. The court can do within that limit, but court cannot reduce less than 6 months or less than 3 months. Court has no such power. That is what the court says. Now, in certain appeals, the issue has also come. See, for example, the lower court has had no case for prosecution on the basis of material, it comes to their view. Now matter comes to the High Court. High Court says that two views are possible on the basis of circumstances. In those circumstances, the courts have taken a view. Even if the two views are possible, and lower courts have taken one view, and on that basis has held that prosecution cannot be launched or is to be quashed, then High Court will also not reverse that if two views are possible. So that is the general proposition which the courts have said. Now, as the Ranka sir has mentioned, that these days Income Tax Department is very serious about launch of prosecutions. We have seen the reports, time to time reports are coming. Prosecutions are being launched or they have been initiated in a very large number of cases. Figure shows that in 2016 there were about 1800 prosecutions launched. In 2017 more than 2500 cases were launched and all that. And similarly compounding has also been taken. So all those cases, and in certain cases the department is also seriously proceeding with the matters and representing before the courts. So in all those cases we have to be very serious about the things. And whatsoever the past is there, we cannot do, we have to defend all that. But at least for the future we should be very cautious about these things. And for the past also, it is very important that from the day one when the notice is received, we should make the proper case. If we do not put the proper facts, proper case in a particular manner, then it may be difficult to further defend our case in the future. So that is very important, we should keep in mind. With this, I am thankful to you for listening to me in this discussion.
Chairman sir, your concluding remarks.
Thank you, Gupta ji, for exhaustively explaining, clarifying, and showing the way whereby immunity can be availed of, or the procedure whereby question of any penalty or prosecution may not arise at all. I for myself would like to mention, once we accept a brief on behalf of a taxpayer, it becomes our bounden duty to be cautious, careful, and have in-depth knowledge which can be and should be used while carrying on the noble profession of accountancy or of law. It is our duty, because the legislature trusts you, whether you are an advocate or a chartered accountant, and fits you in the capacity of a self-assessment officer. Income tax officer is next to you. It is you who are at the top. It is for you to prepare the return. And if you very cautiously and carefully, considering all the provisions of law, prepare a return, be rest assured the provisions mentioned by my learned brother may not step in. The moment the return prepared by you is accepted under section 143(1)(a) or after scrutiny under section 143(3), return income is accepted, question of neither penalty nor prosecution would arise. I may also mention that underreporting may cover a case where there is difference in between the returned income and income computed under section 143(1)(a) also. Because if there is apparent and patent addition based on the information contained with the return itself, which is not debatable, just as, to illustrate, income tax is not deductible. You have properly shown it in your profit and loss account. However, while preparing the return, you do not offer it or deduct it or add it to your income. I for myself would be of the view, and even if there is 143(1)(a) assessment, a liability for penalty may arise. Second part. Second duty of yours is at the stage where any notice for penalty or prosecution is initiated. Humble request is, go very minutely contents of the notice and examine whether it fulfills the basic requirements of the relevant section, and find out if there is any slackness or ignorance or misunderstanding or non-proper understanding on the part of the person who has sent you the notice. Starting with, as you have noticed, underreporting and misreporting. Two charges are there. Underreporting is the broader charge, and misreporting is out of it. Therefore, it has to be ascertained and determined by the assessing officer as to what extent there is underreporting or misreporting. You have rightly mentioned word satisfaction as existing under section 271 of the old Act of the 61 Act is not in section 270A. Word used is determination. And for determination, in my humble submission, question will arise. When, after issuing a notice, he is imposing the penalty. Therefore, humble suggestion is, first thing which you have to do, that in the detailed reply to be filed, clearly specify, we humbly submit, we have not committed any default under section 270 capital A. There is no non-reporting, not reporting or misreporting on the part of the assessee. And further add a line, in case Your Honor still feel that there is any non-reporting or misreporting, we humbly request you to let us know the items on which this liability, according to you, accrues. After receiving or that reply or explanation or clarification from him, onus shifts upon you to discharge that neither you are liable in the category 1 nor in the liability in the category 2. And at that stage also, don't be simply satisfied by mentioning that we have received your communication dated such and such. You must explain, after going through the assessment order, the material facts on the basis whereof you can say that either of the two charges are not there. That's why the legislature very rightly have explained in the section itself. Earlier in 271C, you do not find what is meant by concealment of income or furnishing of inaccurate particulars of income. And it is all just made law, explaining as to what is the meaning of the two expressions. Vis-a-vis here, right thing which the legislature has done is that they have notified what will be treated as non-reporting and what will be treated as misreporting. And they have also given the examples. I may appreciate Mr. Vadva, his representation as to the clarifications in the section itself. Your representation was by way of the circulars, but the legislature have taken a note of it. And they have very well guarded, and rightly so, section 270A, 270AA, both of them. Now, old explanation 1 to section 271(1)(c) stands in the present provision also. And you will again find that explanation 4 of 271(1)(c), it also is operative in the present provisions. Apart, all terminology of various judicial precedents over years would be equally applicable to the present sections. However, I may agree with you, penalty is not automatic. Onus first to be discharged is by the assessing officer. And it is a shifting onus. After it is leveled against you, it is for you to build up your case and say that the charges leveled are unfounded and therefore there is no liability for the specified item or under the relevant section. Therefore, as submitted, non-reporting is broader and misreporting is specified. Therefore, there may be a case where if there is, on account of misreporting on the part of claim of the assessing officer, CIT appeal may hold it is not misreporting, it is underreporting, therefore the liability of penalty may not be 200%, maybe 50%. Therefore all aspects are subject to scrutiny. Another aspect which I would like to deal with is that immunity. With regard to that issue, as to the period after service of the rejection application, I for myself would like to take it view that on the date of receipt of the rejection order, 30 days commence therefrom for filing the appeal. Reason therefore is the legislatures in their wisdom thought it proper to provide you an opportunity avail under section 270AA. And if that has not been accepted by the administration, then there is no fault on you. One side you say, you will not be preferring an appeal. And if you do not prefer an appeal, then alone that section would be made applicable. That's why provisions to or limitation period in respect of penalty remain in disguise during that particular period. And above all, don't wait further, though you are entitled to file within 30 days. And you have got ample power with the CIT appeal for condonation of delay. It is already provided in the section 249 itself. Therefore, on bona fide belief, on reasonable interpretation, we would like to take a view that 30 days from the date of receipt of rejection order of the assessing officer, the time would commence. For 270AA, one more clarification I would like to give. Probably my reading is that if for 1 year on a particular count, penalty has been imposed. In succeeding years, on the same default, no penalty will be levied. Illustrating, assuming you have not disallowed any expenditure which is disallowable. And in 1 year, it is noticed, addition is made, penalty is levied. Then in second year, or third year, or succeeding years, if for the same very reason any addition is made, penalty may not be leviable under section 270 capital A of the Act. Friends, with regard to the prosecution, I would simply like to say that we should be very cautious about the abatement provisions. And we have seen few cases which have cropped up during these last 5 years that our friends are in problem. Therefore, whether a chartered accountant, just as the illustration was given, that vouchers are given to him, books are being got prepared by him or through him. And if there is something found which is apparently, patently, prima facie wrongly entered, probably the gentleman may be in difficulty. Claiming that we don't have the power to investigate, but your bounden duty is to examine, scrutinize, and on behalf of the principal, when a duty has been given to you, to seek necessary clarification from the principal and be satisfied. Don't keep your eyes closed. If it is white, your client say it is black. Don't accept that it is black, white is white, black is black. You will have to be bold enough, and that strength in you to develop only when you know law very deeply, and your inner conscience makes you a strong person. Life is meant to live with conscience. Fear none except one who is above all. Who is that? The God Almighty, your own conscience. Friends, therefore, with all apologies, I would again like to mention our duty in the Federation is to make you a better person. Not only a better professional, but much above that, because the precious life which God Almighty has given to each one of us is so precious. It is not to be wasted. It is not to be withered out. It is not for defaults. It is not for misdeeds. It is not for violence. It is for doing something which make you a man, a human being, not only a human being. I am thankful to the organizers for providing this opportunity. You always give me a latitude to speak whatever I feel. Thank you. Now for questions and answers. And because the subject is so vast, there may be a number of clarifications necessary after Mr. Gupta has spoken and I have expressed. I will keep it not only 5 minutes, I will extend to a period of 10 minutes. Thank you.
Thank you so much, Chairman Sir, for those valuable inputs. At this juncture, I would request Shri Hemant Parak to honor our Chairman Sir with the memento. Because of the lack of the time, I think we will have to take this. Okay, with the Chairman's permission. Yes, sir.
10 minutes. We have 10 to 10 minutes.
Okay, sir.
If there are any questions, if there are no
Right, sir. Please accept the memento. We can take question and answer for 10 minutes.
I may just
I have some reservation with regard to the Sir, I have reservation with regard to the interpretation given for filing the appeal, as you have suggested that it should be 30 days after the date of order of rejection application. But to my mind, if that interpretation is taken, that the provisions regarding extension of time will become odious. Because if 30 days is taken after the rejection order, then there is no need for extension of time from filing the application to the date of order. So to my mind that
2:1. However, I already cautioned that section 249.
my suggestion is it's a very important issue. We will seek clarification from the government and we will send it to all of you for it. It's very important issue.
The chairman of representation.
I will do it, sir. I'll do it.
Please wait. Clause 249 again he has the ample power. Just as in the Illumination Act, section 5. Similarly, that power is already there.
so sir, better way is that 30 days are to be counted from the date of assessment. No. Sir, what I want to say that we have to be cautious that within 30 days we should file the application, then the period will be extended.
The time is fixed, 30 days is fixed. It cannot be extended by the assessing officer. 30 days cannot be extended for filing of the application.
No, that
Time limit has been given. And
I am not saying. What I am saying that when the assessment order is, as Guptaji said that on 7th of October, that assessment order is received by the SSC. Within 30 days from 7th October, appeal is to be filed. So we have to be cautious that we should file application within those 30 days. If SSC will file the application within those 30 days, then extension period would be available to the SSC, otherwise not. That is what I suggest.
end of the month.
Yes.
Yes. End of the month in which that order is received.
Yes,
That is only to file
That is-
application.
that is
the maximum time limit available.
I suggest only to be cautious.
That is the maximum time limit available. I say we receive a
If we want extension period, then we should file within those.
So sir has just about the point as regards the quantification of the penalty. After the or as when the income is subjected to penalty is varied because of rectification or say the affiliate. I just would like to dwell my attention towards subsection 1A to section 275 that provides that mechanism is there. 275 subsection 1A. It says that after the availability of the appellate product, whether it is by the CITF terminal or so on, then the finally assessed income has to be kept into mind, and the penalty amount of the penalty can be revised by the AO after the receipt of the order. So that mechanism is already in mind. That is just wanted to. It's a revision of the.
Here is the senior advocate, KL
Gupta. Mr. Gupta, if in a survey case, some income is rendered by the SSC, and at the time of filing of the return, he has declared that income in his return. My question is whether any kind of penalty under section 271A, AA, or even under section 271C, which is not now in operation, whether that will be imposed or not. No, I'm saying survey. As far as search is concerned, now specific provisions are there. But as far as survey is concerned, those provisions are not there, although there are judgments of the High Court, Delhi High Court, SS Pharma, and Gujarat High Court in Ahmedabad. But the issue is that in most of the cases, those penalties have been upheld and matters are in the High Court. And in some cases, penalties have been waived by the tribunal, but the department has filed appeal. What is the position in section 271C and also under the new provisions of 271A and AA?
See, as per the new section, this section, the language of the section is in that way that income assessed under 143(1)A, we say this is the assessed income. So if I have already taken that in the income, so section 270 capital A will not assess income. That is the language.
As far as section 271A, 271C is concerned, there the wording is in any proceedings, and they are claiming that proceedings start from the date of survey. That is the only difference.
Can we have the last question, please, with your
With regard
permission?
to the survey returns, issue to be considered is this. Base is always returned income. And if after survey, and by that time you have not filed the return, you cover it in the return, then question of any penalty should not happen.
The argument of the department is that proceedings can be initiated at any time of proceeding. They are now claiming that proceedings are initiated at the time of survey and not at the time of filing of return. That is the issue.
So assessment proceedings does not commence at the time of survey.
This is what has been
our point. But they are
You are
not.
right. You are right. They are wrong. You are right. But
There are no judgments of the High Court.
examine those cases. Examine those cases where surveys, earlier return has already been filed. Thereafter there is a survey. Then you file a revised return. Then question may fine.
Chairman sir, with your permission, can we
Yes,
proceed further?
Thank you very much.
Thank you, sir.
very much for permitting me to
I would request Hemant Bhai to please present the memento to our chairman, sir. With a great round of applause, please. Help us in welcoming our chairman, sir. Thank you so much, sir, for your valuable time. I would request Shri Arvind Chani to present a memento to Gupta, sir. Arvind Chani, sorry. sir. I would request Shri Ashok Mandani for the finding out of the lucky draw winner of this session. Three four eight.
Next.
088.
Two fat ladies. Two fat ladies.
Lady is already gone for 029. 29.
Any takers? Congratulations to the winner. And the next number is
273.
273.
I am here. Organizer, no role to play in this.
So can we congratulate the winner? Fine, I would request Shri Ashok ji to propose vote of thanks.
Friends, I cannot express how proud I am right now. I practiced in Mumbai for the last 25 years, but my articleship is from Jaipur. And my articleship was from Mumbai and company. And in those days, we were used to hear the legend of Shri N M Ranka. Morning, just I was wishing to request Pankaj Diya sir to introduce me to N M Ranka sir. And my team put me with him on the dais. It's God thing. Yeah. So I'm very grateful. India is a large country and we are flooded with non-taxpayers. And more still we have large population which is not paying taxes. And those who are paying taxes sometimes very aggressively believe that they can default and evade taxes. Sir rightly said, time is not far when the arrest right might come under Income Tax Act. We all have to be prepared for that. And Speaker, we know we go for assessments how whimsical are the tax department, tax officials. One clerk, he wanted a flash of pond just because he was just going to buy a flat. Whereas the handsome satisfaction was already given to the seniors. And I had to spend 5 hours to reverse the penalty order and just visited the site with the AC. I told him, sir, all kind of submissions, satisfactions have been granted. So we were saved just because there was no entry in the register. I could get the order reversed, but I had to spend 5 hours to get that order reversed. And on the same floor, same day, another DC comes to me and says, Ashok, your penalty reply has not come. Give me back date. This is the scenario. So, sir, I just gone through briefly the article written by sir and his presentation.
It's really clarified a lot of doubts about the penalty proceedings on our mind, and I thank for his beautiful presentation and the article. With these words, I propose a very, very hearty vote of thanks to the legends of all the Thank you very much.
Thank you. The vegetarian and Jain lunch is available on the 3rd floor Accord, and non-vegetarian lunch and vegetarian lunch is available at Primrose on the ground floor.